Hey folks, thank you for joining us today. Dear VA Guy, Dale Davidson here. And hey, let's just jump right into it today. Just how important is a medical diagnosis? And hey, can you diagnose yourself? We'll be answering those questions as we go through our little video here today. So look, remember, the first requirement for a grant of service-connected disability is competent evidence that you currently have a particular disability. Compensation benefits are only available to you if you have a current disability. If you don't have a current disability, you can't get disability benefits. You're not eligible for compensation simply because say, well, I contracted a disease or suffered an injury while on active duty. Well, you've got to have a disability, okay? Did you have an actual injury? I was exposed to Agent Orange. Okay, you're exposed to Agent Orange, so what is your disability? Well, I don't have any signs. I don't mind, prostate cancer, no, this, no, this, no, this, no. So just because you've been exposed doesn't mean that you're entitled to compensation. There's thousands of veterans that have experienced illnesses or injuries in service or exposure that left no lasting symptoms. These medical conditions are considered acute, transitory, temporary, okay? And you just can't get compensated for them. Again, and I just mentioned simply proving exposure to Agent Orange or the Persian Gulf burn pits, Camp Lejeune. We were in Camp Lejeune and drank some water. That's not sufficient to establish entitlement to service-connected disability. You've got to have an actual injury or actual disability. If you can't show this, you can file a claim, but you're not going to go anywhere. So the question is, what evidence is required to establish the existence of a current disability? Do I have to submit the required evidence? The answer is no. I mean, if I was a veteran, I don't have to be the one to submit the required evidence, okay? In many cases, I can submit less than what is required for my current disability in the form of, buddy statements and things of that nature. I can submit a statement, a self-serving statement that says, man, I got this persistent cough, I've got this persistent backache, my knees always ache, whatever it may be, and that provided that and I'm a technical term here, McClendon elements are satisfied, that's going to be enough for the VA to trigger their duty to assist. Remember, we've talked about duty to assist before, and that's where the VA will arrange for a free C&P exam for you. Now, what are the McClendon elements once again? Okay, competent evidence of a current disability or recurrent symptoms of a disability. That's number one. You've got to have evidence establishing that the event or injury occurred in service. Yes, I was in Vietnam. Yes, I was exposed to Agent Orange, or yes, I was in Camp Lejeune, yes, I was in the Gulf War, that I was there, so therefore we've got the evidence, okay? An indication that a disability is associated with my service. So because I was exposed to burn pits and those toxic fumes, I now have a chronic upper respiratory problem, okay, because of my exposure. But number four on the last of the McClendon test is that there's insufficient competent medical evidence on file for the VA to make a decision. So those are the four elements of McClendon. Okay, so anyway, you've got a medical report prepared by a medical professional, and that may or may not end up in your file. But usually medical reports are competent evidence of a current disability. Now, I would suggest that you make sure that whatever doctor is doing this is an actual licensed doctor. Don't get PAs to do this. I mean, they are very competent people, but get a licensed doctor preferably somebody who specializes in your disability. For instance, if you're claiming PTSD, a psychologist or a psychiatrist, okay? Generally, as a general rule, medical doctors are not competent. I say they're not competent, but they don't have the same training as psychiatrists and psychologists for PTSD. So the evidence is required to establish the first element of service connection, the existence of a current disability, okay? The disability doesn't have to be a specific medical diagnosis. Well, I've got pain in my hip, or my pain in my knee, and so it's not the fact that, well, I'm diagnosed that I've got rheumatoid arthritis, okay? It's just that I have a disability because of the constant recurring pain. Pain, which is not connected to a medical diagnosis, meets the current disability requirements if it results in functional loss. So my pain, if I've got pain in my knee, and I'll say, well, every week I get a pain in my knee and there's just no way that I can even walk. I got to sit in my chair, put ice on it, and because it'll swell up like a basketball, because I have functional loss. I can't walk because of the pain in my knee. However, my disability, my knee pain, still needs to be described as specific as possible and diagnosed if possible for the VA to address it properly. And in my instance, I'd say, well, every day or every week, it doesn't matter. There's no specific time, but I'll feel my knee getting real tight and starting to hurt, and then it'll just I got to sit down and it'll swell up, and I've got to pack ice around it. So I don't know exactly what's going on with my knee, but I know I didn't have it until I went in the service. I got to describe as specific as possible what my disability is and my functional loss. Well, my knee swells up, I can't walk. Now, please don't get this confused with the presumptive disabilities. For instance, your Gulf War veterans, due to undiagnosed illnesses, as opposed to knee conditions, back injuries, and things of that nature. So if you served in one of those and you have a disability that's been undiagnosed, different set of rules, okay? But just know that more precision is needed in describing the disability. So a diagnosis of a current disability almost always involves medical issues. Competent medical evidence is often still needed to satisfy the first requirement to grant compensation. So what is competent medical evidence? According to the VA, that's evidence provided by a person who's qualified through education or training or experience to offer medical diagnosis, statements, or opinions. Competent medical evidence also means statements conveying sound medical principles found in medical treatises. It also includes statements contained in authoritative in treatises, in books, medical books and scientific articles, okay? So let me give you an example of what the VA thought was competent medical evidence when it denied my client's PTSD. My client went through the CMP exam for PTSD. The PA, hint PA, it's a problem there, filled out the disability benefits questionnaire, and at the end said no PTSD. Well, the problem with that is that the PA could have filled that out. That's not the issue, but the PA would have had to have been under the supervision of a psychiatrist or psychologist, which there's no evidence of that because the PA signed the DBQ, not the psychologist or psychiatrist. So we were able to successfully argue that it was error for the VA to rely on incompetent evidence because they didn't even follow their rules with respect to having a psychologist or a psychiatrist involved in the diagnosis of my client's PTSD. Because as a follow-up to the Disability Benefit Questionnaire, the DBQ, the psychologist or the psychiatrist was supposed to have met with the veteran. That didn't happen either. We were successful in that argument. So the determination of whether there is a current disability must always got to be made by a medical professional or some person with specialized knowledge, education, training, okay? An MD. Now, PAs can do this and look, but they've got to be under the direction and control of the physician, the medical doctor, the psychologist, psychiatrist, okay? We all know that the VA has a duty to assist you by providing a C&P exam, and so that's very helpful. But we have to be careful that they're following their own rules as to who is conducting that C&P exam, whether it be in PTSD terms, psychiatrist, psychologist, or a PA under the direction and control, and that all the rules are followed. Again, PAs are a valuable tool, but ultimately the medical opinion is based upon the person with the specialized training, which is the medical doctor, the psychologist, psychiatrist, and that's not necessarily the PA. Now, that's not to say that you can't provide a medical statement or opinion from nurses, chiropractors, social workers, professional counselors, among others, but you got to be careful to make sure that whatever medical statement or opinion that you are providing is going to be connected to your disability. I always make a joke, you don't want to go see a podiatrist if you're having a heart attack. If you're trying to get PTSD, don't get a diagnosis from a nurse or a chiropractor or a social worker or a counselor. Go straight to a psychologist or a psychiatrist. Okay? That is the best way to assure success. Now, let's say that the VA has medical evidence in your record that is not very good for you, okay? You can always challenge that medical professional with your own medical evidence. You get a denial and you challenge that in your appeal that says, I don't agree with this doctor. Here's my own doctor's opinion, but make sure that your doctor's opinion is bolstered by reports and studies and other things such that the VA would accord more weight to your doctor. And of course, get buddy statements to support your doctor's statement too. You can get statements from your family members, friends, spouses, neighbors. They're not competent as to a medical opinion, but they're competent to help bolster your doctor's medical opinion. Because I'm not competent to diagnose PTSD. And that's the issue I see with a lot of my clients coming in and talking to me. They say, well, I've got PTSD. Well, how do you know that? Well, I just do. Or my primary doctor diagnosed me. That's not good enough. Okay? We need to have a professional who is trained in this to diagnose you with PTSD. I mean, you can report your history, and that's good. You're competent. Family members, friends, all of those. You can identify your medical condition. You can't diagnose your medical condition. You could say, well, Dale has outbursts of anger all the time, and it's highs and lows, and you just don't know what's going to trigger him, and da 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 da. And so I think that he has got some kind of psychiatric thing going on. You can't say, well, my opinion, Dale has PTSD, because they're not competent. They don't have the training. Okay? You, with no medical training, are not qualified to diagnose your condition, let alone anybody else's condition. Okay? You say, well, so-and-so's got diabetes. Well, how do you know that? Well, he told me about his blood work. Well, you're not a doctor. You can't read that. I mean, there's other conditions there. So you just don't know because you don't have the training. You may have an opinion, but your opinion is not competent because it goes to the diagnosis. Okay? So now, if you or your family member is a medical professional or otherwise qualified, has the training, so yeah, well, my uncle's a psychiatrist and he diagnosed me as having PTSD. Fine. We get his credentials, we get the letter, opinion letter saying Dale has PTSD and here's the doctor's credentials, and ship it off to the VA and say, yeah, here's a medical opinion that Dale has PTSD. But only if you've got the correct credentials can you actually diagnose. You can give an opinion as to what's going on, but it's really not competent. Your opinion can bolster a medical opinion, but unless you've got that medical knowledge or training, you can't give an opinion or a diagnosis. The ultimate question is, look, does your diagnosis require medical expertise? Yes, but what if it's a broken leg? I can say, well, I saw him there with a broken leg, and his leg was, I know that because his leg was turned the opposite direction and he was writhing in pain. He dislocated his shoulder. How do I know that? Well, he fell on his shoulder and he was holding it and writhing in pain. I mean, I can say that, but that's not a medical diagnosis, okay? Now, transpose that to, versus PTSD or diabetes or congestive heart failure. PTSD, I can say, well, Dale's got these mood swings, or he's got diabetes or congestive heart failure, but that's a medical diagnosis. I have no training, or you have no training, to make that diagnosis. As a layperson, you might be competent to diagnose a broken leg, but you're not competent to diagnose cancer, PTSD, congestive heart failure, all of those things. So my advice is always get competent medical advice or diagnosis. The lay statements can bolster that, okay? Now, competent medical evidence can establish a current disability, and that can be through your private doctor or the VA medical records or a VA C&P exam, whatever it may be. So you can have letters from doctors. All of these things help. But again, evidence of current disability is required for a grant of disability. And the best way, and really the only way, is to get competent medical evidence or a diagnosis from a doctor as to your disability or your injury. That is the best way. Now, get your lay statements to bolster that, but you must get a diagnosis from a doctor. Hey folks, thank you for watching today. Hey, check out this video on buddy statements. It ties everything together with medical opinions and things of that nature. It's going to be really beneficial to you. And until next time, be blessed.